I would suggest to the court that any person who has knowledge of either that settlement amount or the plea negotiations that were the beginning of the case should just be presumed to be biased and be gone. I mean, I ended up having to use a strike on that last juror because he said he would ignore the $27 million judgment. So first of all, Your Honor, I'm asking the court to start the analysis from a presumption of prejudice based on the pretrial publicity. The court in Warren, State of Minnesota versus Warren, which is at 592 Northwest 2D, references that in light of massive, unrelenting pretrial publicity, prejudice in a jury pool can be presumed. If publicity during the proceedings threatens the fairness of the trial, a new trial should be ordered, but we must remember that reversals are but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception, quoting from Shepard. And essentially, Judge, this is what the defense has been complaining about since the beginning of this case. You have elected officials, the governor, the mayor, I'm making incredibly prejudicial statements about my client, about this case. You have the city settling a civil lawsuit for a record amount of money, and the pretrial publicity is just so concerning. And I'm looking at my remaining strikes, and I'm looking at the fact that we essentially still need 3 sitting jurors plus 2 alternates, and looking forward. Virtually every single one of these people is nearly identical to this last person. I've used 11 strikes on people who have had very negative things to say, but they can be fair and impartial, and no matter how you ask them, that's going to be their response here in court. It's the rare person that comes in and says, no, I can't, right? So if we start from the presumption of the prejudice, I think that, and then also take into consideration the sum total of their questionnaires, and the cause becomes the cause challenge becomes a different analysis at that point. So I'm asking for that relief, first and foremost. Second, I'm asking the court under State versus Salas, S-A-L-A-S, 306 Northwest 2D, when someone is aware of the pretrial media, I should be given, at the very least, should be given more latitude, especially about the settlement. More latitude. My latitude was very limited in that last juror and what I was allowed to ask them about their perceptions of the settlement. And in fact, I think the court should be granting me more latitude to inquire about that under these cases. It specifically says, when a juror has been informed of matters through the news media, they'll not automatically support a challenge for cause, but this does not preclude inquiry regarding such exposure, since it might produce a fixed and prejudicial opinion. The court should view such situations with careful scrutiny and permit counsel wide latitude in voir dire inquiry because of the obvious peril to the presumption of innocence in a fair trial.
Is there anything that you felt the court did restrict you from asking about the settlement?
Well, Judge, in the pretrial conference, we had the sidebar where I asked the court specifically how far I was allowed to go. And what I heard, I mean, I wasn't saying that I didn't think that the court denied me the ability to inquire about it, but what I heard the court say was you were going to not let me go too far about it.
Well, I think you have a right to go beyond what I had basically said or what they had basically said. But they had heard about it. They didn't think it was going to be a problem for them.
Well, I mean, and I just think ultimately, Judge, I mean, even then in his inquiry, when I asked him about that, he said, well, I guess if I'm not allowed to, I wouldn't talk about it. But again, I don't necessarily think the question is, are they going to talk about it in the jury room? It's what has it done to their perception of the presumption of innocence and proof beyond a reasonable doubt? And so we have a juror who's aware of it. So in the immediate remedy, Judge, I would ask that I be given that strike back and that juror be stricken for cause.
All right. Mr. Slisher, do you want to respond to all of that?
Yes, Your Honor. The state asked the court to deny the relief that's been requested by the defense because there's no reason for it. Once again, it's a solution in desperate search of a problem. I think that this $27 million settlement has been frankly overblown, and I think that that has been displayed in what we've seen so far. First, with respect to the jurors' awareness, right, we've gone through to this point, 14 jurors since the news of the $27 million settlement happened. 14. Out of the 14, only 3 had heard of it. One juror, the first juror, expressed that would cause her to, it would affect her deliberations, right? The second juror was pretty neutral. He was the guy who talked about getting headlines all of the time. It didn't make even enough of an impression upon him to mention in his initial round of questioning. It was just kind of along the list of things and headlines that he scrolled through, something he happened to see. And this third one said he absolutely could set that aside. What the defense is asking for is not a presumption of prejudice. He's asking for a presumption from this court that the jurors, the prospective jurors who he's questioning, are lying to him. I mean, that's what he's essentially asking the court to find. Because these citizens are being placed under oath, they're raising their right hand, they're telling the court what information they've been exposed to and how that information may or may not affect them. And you can see different people have things affect them in different ways. Now, we know that there's pretrial publicity in this case, and there has been since the moment the news broke and the Facebook video was released. And it's not because of any conduct of the state or government officials. What I hear him saying is, oh my gosh, we have elected officials doing their job, right? They're making statements. They're talking to their constituents. In the case of the city, they settled a civil claim because they felt apparently they needed to do so. That the government, the state, I should say, this prosecution team, again, has absolutely no control over that, nor should we be meddling in some other instance I could see where you could find fault if we were trying to control the flow of information or the outcome of the civil case. They need to do their jobs. We need to do our jobs, and we all need to stay in our respective lanes. This is one of those situations where the cure is the saying, don't just do something, stand there. And that's what you exactly need to do here. We have a process of voir dire that we put people under oath, and we ask them questions, and we get their answers. And on an individual and a particularized basis, the court, in its discretion, makes the determination as to whether or not the person should be stricken for cause or not. And we're on day 6, right? In this day 6 of jury selection, of which you had 3 weeks slotted, we have plenty of time. We have, 329 prospective jurors have been identified in this case. And we're through, what's the number we're through now? We're below 100. We have plenty of time. We have plenty of people. We can take all the time questioning that we need to determine on an individual and particularized basis whether there's prejudice to the defendant or a need to strike people for cause. That just hasn't borne out so far, and I don't think that we should overreact to what's been happening. This case is in the news. It's going to continue to be in the news. There will be a story about this case every single day, no matter what. That is going to happen. And what our job here is to determine whether the particular prospective jurors in the box have been exposed to media, if they have biases that they can't set aside, right? That's what our job is. But it's not to make a prejudgment as to the rest of the panel. As to the last juror, the defendant doesn't need to strike back in that particular instance because the juror did not demonstrate any reason to strike him for cause. He stated, and it was a considered opinion, and you saw him, right? I mean, you're observing him as he's talking. I understand he was masked that whole time, but the sincerity with which and the contemplativeness with which he gave his answer that, I could set that aside because that's my job, because that's my duty, and that's what I would do. And this particular juror is the one who would know a little bit about that, having previously deployed as a member of the Minnesota National Guard and knowing that sometimes things are hard, but you're supposed to do it, so you do it anyway. He stated that under oath. There is no reason to disbelieve him, and the court should deny the defendant's relief.
Well, a couple things. I probably was not as articulate as Mr. Nelson was when I mentioned the concern about the plea bargaining, the concern about the $27 million. But I pretty much said that it's going to be a quick road to a challenge for cause. Maybe, so that's saying I'm presuming prejudice in those. But I don't think I can listen to a juror who says, I can be fair and impartial. Yeah, I was aware of that. And to be honest, our last juror, I don't think he was lying when he said that settlement thing, I don't think that would affect me at all. I think it was more maybe perhaps a lack of introspection about the other firmly held beliefs that he had. He had a very negative opinion about the defendant and a variety of other things. And I don't think he was intentionally lying. I think it's true of a fair number of jurors. They just lack the introspection to say, yeah, I don't think I can be fair and impartial. Some have not. I don't think I have to accept a juror's statement, I will be fair and impartial, when everything I see, the totality of the circumstances, is they can't be. It's almost humanly impossible given the opinions they hold. And if they are confirmed that they still hold those opinions today, and they are that strong, and considering everything, I don't believe that's true. I think it's appropriate that I accept the challenge for cause. The state might push back and say, if they say they can be fair and impartial, you have to accept that. I don't think so. I think part of my job in a challenge for cause is to make a determination if they could be fair and impartial, not just did they say the magic words. So I guess I think I'm almost between the two positions here. This has always been my thought, that I have to consider everything listening to this juror, whether there is a challenge for cause or not, based on the totality, not just the words that come out of their mouth. Those are important, obviously. And if they say, I can't be fair and impartial, that's hard to say the reverse. And say, oh no, you can be, and sit on the jury. I mean, that's playing with fire.
I agree with you, Your Honor. I mean, the Court of Appeals, the appellate authority is very clear that you are in a position to look at the record as a whole, the totality, and make that determination on an individual and particularized basis whether or not you believe a cause challenge should be granted or not. And I think that's perfectly appropriate. I think you've stated exactly what the law is and what the process should be, and continue to be, and has been.
And I think, if I could just comment on the two issues that we have currently, there are more, but the two primary ones that are particularly pernicious here is the articles shortly before trial attributing the information to law enforcement officials about plea bargaining. That is particularly problematic, and I said so, because of its impact on the presumption of innocence. The $27 million settlement is unfortunate. It is something to consider. But let's face it, it's not just a legal decision. That's a political decision. And I think people realize that, and they realize that's not anybody in this room who's doing that. And so I think it is less problematic, but less problematic than the other articles that were out earlier. So when you have the combination of the two, I'm probably going to find it hard to say that that person, even if they say I can be fair and impartial, that I would buy it and not challenge it and not grant a cause challenge. But at the same time, there are certain people, I think lawyers get really good at this, about pigeonholing, okay, I know this, I can't consider this, I can consider this. I mean, when I'm a trier of fact, I'm probably exposed to a lot on a court trial. I'm exposed to a lot of evidence that doesn't come into evidence, and I have to affirmatively disregard it and just focus on what I have in front of me. I think certain professions, most importantly lawyers, are trained to do that. And so I have a lawyer up here saying that. I'd probably be more likely to say, yeah, because you've had practice doing it. If I got somebody who still holds these opinions, I think it's a case-by-case basis, totality of the circumstances. I don't think I have the authority to presume prejudice. I'll tell you it is prejudicial. Those articles are prejudicial to the defendant and his right to a fair trial. But the question is, how prejudicial is it to the point where a challenge for cause is appropriate? So I don't think it's so much a presumption as I'm going to hear from them. I'm going to make a decision on the totality and go from there. And I'm not necessarily going to buy everything that comes out of a juror's mouth and not because I'm sitting there lying. They may just be not very self-aware, and it's very clear that they are not self-aware.
I think that's perfectly appropriate. I do want to just mention, you mentioned the third degree, the plea negotiations. Of all of the jurors we've examined so far, if my notes are accurate, we've had one state that they had any sort of awareness of that out of everyone, and that person was stricken for cause. Again, that's perfectly appropriate. We have a lot of jurors to go through. We have a lot of time to go through them, and that's the process that we can use to ensure this defendant a fair trial.
All right, Mr. Nelson, anything else? Or? All right, I'm going to deny the request to reinstate a peremptory challenge, but your observations are noted, and I think they're actually consistent, but feel free to argue strenuously in certain cases, knowing that my standard is not, they said the magic words. Okay?
Understood.
All right, let's move forward then with the next juror. Juror 71. Juror 70, I believe, was the one who was postponed their service.
They need to be the group. I don't think this group has done.
Oh, that's right. We're back to it's the group. We need the group. All right. Thank you for reminding me.